So how does Bill C-2 expand police powers? There's a number of ways that it does this. One of them is through the Customs Act and through the Canada Post Corporation Act. So dealing with your mail and things that are coming across the border. So at borders, right now, CBSA officers and RCMP have some limited powers to search places where goods are stored for import or export, where they're loaded or unloaded, and things like that. This is going to expand those powers to allow an officer, CBSA or RCMP, presumably or municipal police, although I didn't think I saw that there, to be given, to request and be given access to any place or premises where goods are for export are reported, loaded, unloaded, stored, and to open packages and remove packaging. So they could go into a warehouse at a port, for example, and open packages and look inside those packages, not just look at the boxes and have a dog sniff around the boxes or something. They can actually open them up and look at what's inside under these police powers. When it comes to Canada Post monitors your mail. If you don't think they don't, you are wrong. Canada Post is looking at what you are sending in the mail service. But under the current legislation, Canada Post officers are not able, not officers, but officials, Canada Post officials, are not able to open letters. They can open packages and parcels, and they can open undeliverable items, but they cannot open letters. And so one of the things that's going to be expanded with this legislation, if it passes, is that if an employee of Canada Post has reasonable grounds to suspect that a piece of mail, any type of mail, including packages, parcels, or letters, is undeliverable or violates any of the regulations for what you're allowed to send in the mail, then they can be opened. So it gives them basically just an additional power to open letters. And that makes perfect sense. You know, it used to be that you would think, oh, you can't really send very much in the mail if it's, you know, if it's something that is not a package. But now, given that we can store so much data, so much information on little tiny pieces of card, given that you can have QR codes that take you to places that are, you know, potentially things that shouldn't be sent in the mail, given the way that, you know, certain substances, even a tiny amount of them can go a long way. That's why we want to give Canada Post officials more power to be opening letters, because you can conceal things in letters that you used to only be able to conceal in packages. So it makes sense, and it's not really a huge expansion of their powers. There's also going to be changes to Canada's sex offender registry. And this one is very interesting. There's a couple changes that are coming. None of them are particularly interesting, but the big one is that the sex offender registry is going to be changed to allow disclosure of the registry information to witnesses or victims in criminal cases if it would assist the investigation. So information that is in the sex offender registry right now can only be disclosed in certain circumstances. It's not just a publicly accessible database. I can't log on and look up information. But now if you make a complaint about some sort of an SA, then potentially, if this legislation passes, the police can disclose the information in the sex offender registry to you if they believe it would assist in the investigation. And if there's a witness, they can also disclose it to them. So that really, you know, expands the use to which the sex offender registry can be put. There are also going to be a couple changes to the warrant provisions in the criminal code, and these mostly deal with searches of electronics and electronic devices. And all of this comes back to a case that was decided by the Supreme Court of Canada last year that dealt with your right to privacy and your IP address. So there's going to be changes to allow searches of computers for computer data and seizure of the data. Right now, there's a convoluted process where they can seize the device, and then they have to search the device for the data, and they have to get a separate warrant for that, and then they have to get, file all these documents for seizure of the data. They're going to try and consolidate that into a more efficient process. That's not really a huge expansion of police powers. But what is a huge expansion of police powers are changes that are coming to the electronic information that police can get. So right now, police can't get a lot of information without a production order for subscribers They can go, my internet is through Rogers or Shaw or who else does internet in Canada? TELUS, Bell, one of those companies. They can go to them and they can say, I have a production order from a judge that says that you have to give me this information. But without some sort of prior authorization, the companies don't have to turn that information over to police. So now they're changing it so that subscriber information, including a name, a pseudonym, an address, a phone number, an IP address, account numbers, the types of services that are provided, and any registered equipment. If you register your equipment with your internet service provider, you register your laptop, they're going to be able to give that information to the police. And the police aren't going to need to go through a judicial authorization process for this. They can actually make a demand to these telecommunications providers companies for subscriber information if they have reasonable grounds to suspect that an offense has or will be committed and the information is necessary for that investigation. Reasonable grounds to suspect is a very low bar. It's just a suspicion that's based on some sort of objectively reasonable evidence. Just a suspicion. They don't have to believe an offense is going to be committed. They just have to suspect one will be committed. So it's a low bar, and it's a way in which they can get a lot of personal information with not meeting a lot of hurdles. But you can't make the demand to the person who's subject to the investigation. So the demand can be made to anybody, but it can't be made to, like, if I'm under investigation for sending mean emails on the internet, then they can't ask me to provide my own information. That would obviously interfere with your right to silence. And the demand is also limited to whether the provider provided services, the type of services, when and where they were provided, and if the company knows of any new service provider and the municipality and province locations for the where. And then once they get that information, they can then take that and get an order from a judge to produce the actual subscriber information. So this allows that process to unfold with maybe enough information to assist an investigation that can then assist them in getting a warrant, but it also allows them to bypass a lot of information. Now, it also opens the door to telecommunications companies voluntarily providing this information. The police can ask and they can disclose it, and they don't need to have any grounds to ask. They can just phone you up and say, hey, TELUS, can you give me the name and address of the person who has this cell phone number? And the telecommunication companies can do that. They probably won't for other reasons related to their own liability, but they can. And in exigent circumstances, and it's hard to imagine what internet-based issues are going to result in exigent circumstances, but in exigent circumstances, the police can get this information without a warrant. And the last thing that is really interesting about this legislation that expands the police powers or limits and intrudes upon your privacy rights is that judges are now allowed to authorize the police to get tracking data for similar items to those sought in a warrant. So if there's a warrant for a laptop, your MacBook, the police can also authorize tracking data for your iPhone or for your AirTags and your Apple Watch. They can get that tracking data, if it's available, authorized in the warrant for similar things to what is being sought in the warrant, even if they don't know that those similar things might exist. Essentially expanding the ability of police to search out electronic information without necessarily having the grounds that would otherwise be required in a warrant, knowing that the thing is going to be in the place searched. So those are the expanded powers. Some of them are concerning, some of them are not so concerning. And I think, things that are designed to make the process more efficient are fine when they still have appropriate safeguards for privacy rights. And as soon as you allow police to do things warrantlessly in exigent circumstances, you open the door for a lot of abuse of that power, especially because there's not a lot of legislation that defines what exigent circumstances is, nor case law that defines what exigent circumstances is in the context of electronic-based investigations. But it remains to be seen how this will be used, if it passes at all. And I know that these provisions are definitely the subject of a lot of interest and a lot of debate. And I expect that Parliament, when it resumes in the fall, will be hearing from a lot of experts about the various privacy implications of this legislation.